Most injured workers don't realize that there's a single number, their impairment rating, that really decides the value of their case. When looking at evaluating settlements, your impairment rating is the most important thing. If you get it wrong, you could lose tens of thousands of dollars. If you get it right, you can maximize your benefits. Today, we're going to break down how your impairment rating is set, the tricks insurance companies use to keep it down, and the steps you could take to keep that number where it needs to be and to maximize the money in your pocket. What is an impairment rating in your workers' compensation case, and when is it usually determined? An impairment rating, generally speaking, is a number given from your doctor to describe your overall level of permanent disability. It's a permanent disability rank. It's given after you reach maximum medical improvement, MMI. Your doctor is going to offer his opinions on your level of permanent impairment for whatever disabilities you have, and the insurance company oftentimes is going to ask their doctor to examine you and offer his opinion on your maximum medical improvement. In New York State, there's generally two types of impairment ratings. There's the schedule loss of use. It's a percentage loss of use of a specific body part. Schedule loss cases usually deal with extremities, arms, legs, hands, feet, fingers, toes. Hearing and vision is included in there. A non-schedulable injury, a non-schedulable impairment rating is usually an assessment of your overall level of permanent disability as a whole, as a human, as a person, whether it's partial or total. Most of the time it's partial, and those usually are the cases, the head, neck, and back cases. They could be systemic injuries, COVID. Some people are dealing with long COVID issues, heart attacks, strokes, things like that sometimes occur at work. And those are your non-scheduled cases. These are the numbers that we use to assess and determine your overall settlement value when it comes time to settle your case. And sometimes we try to kind of figure out what your impairment rating or your schedule loss might be, or what we're anticipating it's going to be before we get it, so that we can start the ball rolling on a settlement negotiation. And we can do it before we get that number, so that there's a little bit of uncertainty or confusion with the insurance company as to what they're going to expect. Since we don't have any hard numbers yet, we can usually ask for a little bit more and try to pin them back using that. But when your injuries are reaching maximum medical improvement, that's when we start talking settlement. That's when we start anticipating permanency, schedule loss, and things like that. How does my impairment rating determine how much workers' compensation pays? It's for non-schedule loss of use cases. The first thing the judge is going to do is look at your impairment rating, look at what your disability level is from a medical or a psychological perspective, or both if you have multiple injuries. So they're going to figure out what your disability is. And the way it works, there's different tables depending on the type of injury you have, the body part, and whether it's a soft tissue, whether there's been surgical intervention. There's a whole bunch of different factors that tell the doctors which table you fall into, and then how they are to assess the appropriate letter grade to give you. Vocational factors come into play as well. So not only is the judge going to figure out what your overall level of permanent disability is based upon your injuries and your disability alone, the judge will then factor in your vocational background, and that could be used to increase or decrease your overall permanent impairment. And ultimately, it's referred to as LWEC, loss of wage earning capacity, for those core body injuries, those head, neck, and back injuries. How much has your wage earning capacity been impaired as a result of your injuries and your disabilities? And how does your vocational background factor into that as well? So one example that I always give, if you take two people with the exact same injury, they both have herniated disc in their back with ridiculous symptoms with surgical intervention. They had the same injury, the same surgery. Person A is Harvard educated, speaks 3 different languages, is an astrophysicist, is studying for his MCATs to become a doctor. He's a brilliant guy. Person number 2, person B, has the exact same injury, but unfortunately, he might not be the brightest guy in the world. He can't read and write, can only speak 1 language, and the only job he's ever had in his lifetime is sweeping floors in a warehouse, and he somehow hurt his back. You have these 2 people with the identical injuries, but one of them, their vocational background makes it easier for them to find future work. The other person, their vocational background might make it more difficult for them to find future work with that same injury. So their vocational backgrounds are going to factor in. So let's say the judge determines that, just to make it easy, both of these gentlemen have a 50% permanent partial disability as a result of their physical injury to their lower back. Well, person A might be determined to have a 30% loss of wage earning capacity because it might be easier for him to find work down the road than person B, who might be found to have a 75 or an 80 or 100% disability when you factor in his vocational background. So when determining impairment rating, you need to consider your level of disability that results from the accident, as well as your vocational background. Now, when an LWEC determination is made, the percentage of loss of wage earning capacity corresponds to a number of weeks of benefits that you receive your compensation for. And the higher your LWEC, the higher your permanent disability finding, the longer you get money and the more money money you get over that time. So if a judge finds that you have a 75% loss of wage earning capacity, you would get a 75% rate of compensation. So you get 75% of 2/3 of your average weekly wage, or 400 weeks. So 400 weeks is 7.69 years. So if you have a 75% disability, you're going to presumably be entitled to that rate of compensation for 7.7 years. Or if you go back to work, it would be reduced. Just to contrast, a 50% disability gets you a 50% rate of compensation. So it gets you half of 2/3 of your average weekly wage, or 1/3 of your average weekly wage for 300 weeks. 300 weeks is 5.77 years. So a little more than 2 years less time that you get that money, and you're getting less money. That's how we figure it out. The higher your LWEC, the more money you get, the longer you get it. Now we're shifting gears here for those schedule loss of use injuries, extremity injuries, those arms, those legs, those hands, those feet, those fingers, those toes. The state has given each body part a value. Total loss of use of an arm gets you 312 weeks of compensation. A hand is 244, a foot is 205, a thumb is 75. Each body part has its own value. So if the doctors agree that you have a 10% SLU, schedule loss of use of an arm, you're going to get 31.2 weeks of compensation. Now here's where a big difference comes in between schedule loss and non-schedule loss cases. In a schedule loss case, the insurance company gets to take credit for the prior payments that have been made to you, not the medical payments, not the money they've paid your doctors to treat you, but the money that they've paid you. So if you've got compensation for lost time, they're going to take credit for that. If your employer paid you sick time or salary or whatever while you were out, they're going to get a reimbursement. They're going to take credit for that. So there is a deduction. If you did get paid compensation for your lost time, they're going to take credit for that out of that schedule loss of use award. What are things that can lower my impairment rating? How can you hurt yourself, and how can you be hurt if you're not paying attention and you don't have a lawyer who knows what they're doing? And there's a couple things that could really lower your impairment rating that you want to look out for. Number one, not getting a rating from your doctor. It shouldn't be as common as it is, but people miss the boat all the time. Oh, I had an appointment last week and it was too hot out. I didn't feel like going. Go get those reports. Get your doctor's opinion on record. Get something to use to your advantage, because if you don't do it, some judges won't even give you a second shot if you miss the first one. That's probably the biggest tip I have. Follow up with your doctor, keep seeing your doctor, and get that permanency report from your doctor. The IME doctors often provide a lower assessment of your level of disability, just statistically speaking. But if that's the only evidence that's in your file and you're precluded from getting your own report, you're stuck with it, essentially. That's it. We could cross-examine that doctor and try to show that maybe his findings were on the low side, but that's really taking a risk. Not only getting that report, but having a strong report. Talk to your doctor. Let your doctor know what's going on. Let your doctor know about your past history, intervening accidents, prior injuries. Make sure they know all that so the report is solid on its foundation. Because if we can't reach an agreement with the insurance company, we're going to have to take depositions from these doctors. I literally just got off the phone with a client whose case is going down the tubes because his doctor had no idea that he had all this past medical history. And when we started taking testimony, the doctor's like, I had no idea about all this stuff. I didn't know that he had a surgery 10 years ago on his low back. He never told me. And there's no coming back from that. So make sure your doctor knows what's going on. Make sure you see him consistently while you're treating. Make sure you go back to that permanency report. Make sure he knows what's going on with you and your life and your injuries so that his report is solid and strong and you have strong medical evidence. If we can't reach an agreement with the insurance company, it's up to the judge to make a decision, and you want the judge to make a decision based upon all of the medical in a way that's most beneficial to you. And if your doctor seems like he doesn't know what he's talking about, you're going to get hammered. So strong, solid medical evidence will keep your case in a good place when you're going in front of a judge. One thing also you need to avoid: malingering, faking it. Sometimes the insurance company doctor will say there's some malingering and we can go back and forth about what was there. When you go to see the insurance doctor or your doctor, give them the full effort you can. Don't give them the opportunity to say that you were faking it, you were malingering, you were making it worse than it is, you were over complaining about your pain, things like that, because it doesn't look good. And there are certain judges that when they see that malingering, it automatically adds that negative connotation to your case, a stigma, if you will. And to get out of that is next to impossible. You want to avoid the stigma of being called a malingerer. So make sure the doctor knows you're doing the best you can. Skipping treatment. Skipping treatment looks so bad because not only is it an arguing point from the insurance company, not only can they sit there and talk about it, it looks terrible. Not only does it sound terrible to hear that argument being made about you and your case, it actually looks bad because when the judge goes into your screen with your medical reports and sorts them by date and there is a huge gap because you haven't seen a doctor in 6 months, he's going to say, why haven't you seen a doctor in 6 months? You better have a really good explanation because it's going to hurt you. So go go see your doctor. If your doctor's prescribing treatment and giving you appointments and trying to help you, keep up with it. Go to your appointments. Keep up with your doctors. Get yourself better. Intervening accidents. You got hurt in April of this year. We're now in July. And in May, a month later, you had a car accident. Call me and tell me about it. You would be surprised how many people don't give me that information. And then when I go to court and the insurance company does an ISO search, which is a database, and it pops up that you had an accident a month later, please tell us what's going on. Tell us about your prior injuries. Tell us about your subsequent problems, and make sure that we know about it so we can get out in front of those problems and present them the way they need to be presented. Oftentimes, if you have multiple injuries and accidents to the same body part, apportionment becomes an issue. If you broke your arm 10 years ago and you broke it again, well, your break today is going to have to be apportioned between the old injury and the new injury. How much of your permanent disability today, how much of your schedule loss of use today is from accident A and accident B? Make sure everybody knows about it. Please, please, please. Doctor shopping, another red flag, and another thing the insurance company is going to have a parade with banners and floats in front of the judge to make it seem like you are shopping around for the best opinion and not the best doctor when you switch and switch and switch doctors. When you get hurt, you go to the hospital. A lot of times the hospital will have you go see the orthopedist that you saw, the neurologist that you saw, but settle in with a doctor. And if at the initial stages of your case you're not happy and you want to switch doctors by all means. Being happy with your doctor, being comfortable with your doctor is the most important thing to you getting better. And if you're not happy with your doctor, make that switch as early as possible. If you do it at the very end of your case, it looks bad. How do I protect my impairment rating and my money? Tell the truth about your pain levels. Give your full effort during examination. Be honest. The doctors have seen it all. Don't exaggerate. Don't malinger. It's going to hurt you. Disclose your past injuries to you and your IME doctor and your lawyer so that we know about it. We put it on your claim form. And if your claim was already filed and it wasn't mentioned on there, we could file an amended claim form. I'd rather file an amended claim form 3 or 6 months later before somebody else picks up on it and hits you with it. If it's thrown in your face, it's going to hurt. If I do it as your lawyer and file an amended claim form saying, by the way, we left this out, but this is what happened 10 years ago, at least we got out in front of it and we minimized the damage. Attend all of your appointments. Listen to your doctor. Keep your appointments and do what your doctor says. If you're not following their medical advice, if you're not getting the treatment that they're recommending, if you're not going to physical therapy, if you're not taking the medications that they're prescribing you, when it comes time to write those reports and testify, they're going to be honest about it. Yeah, he was non-compliant. I prescribed him physical therapy and he waited 6 months to go and he only went twice. Listen to your doctors. Follow their instructions. Get the treatment that you need. Get yourself as good as you could really get yourself, because that's where you want to be. And this way your case can finish in a way that's favorable to you. Make sure everything is documented. If you did have a past medical problem, an injury, an accident, something, make sure you tell your doctor, doc, please make sure you put this in your report. Please write it down. There's nothing wrong with asking the front desk on the way out, hey, I'm going to come back in. Let's reschedule that appointment. And by the way, can you email me the report from today's visit so I can just review it? Because I did tell the doctor to add some very important information. I want to make sure it gets way in there. There's nothing wrong with that. That's the right way to do things. Make sure you finish all of your treatment before MMI. Doctor, has the patient reached maximum medical improvement? Yes. Has he gotten all the treatment he could possibly need? And the doctor's going to explain every mode of treatment you've gotten and what it's done to you, how it's helped or not helped or whatever. And that picture is beautiful. Make sure you finish your treatment. Highlight your limitations. Explain how the injury affects your ability to find new work. Those are discussions you should have with your doctor. Any prior or relevant medical history that could have an impact on your ability to look for work, make sure your doctor knows about that. If you get a bad rating, consider filing an appeal. Who are you going to talk to when you consider filing an appeal? Your lawyer. So you should have a lawyer along the way while the process is unfolding. Consider settling in advance. I like to start the process as we're getting close to MMI. That's when you want to start that process. So at least starting the negotiation process in advance can be to your benefit, and it can oftentimes result in a higher settlement value. And then the last tip, the greatest tip, have a lawyer. We know what to look for. We know how to argue impairment, schedule loss. We know what to highlight, what not to highlight. We know how to cross-examine the insurance company's doctor to show where he didn't do a good job. Statistics have shown having a lawyer gets you better settlement results, gets you better impairment rating finding, gets you overall better results. Why would you not want to have a lawyer? The consultation's free. A workers' comp attorney here in New York cannot charge you for a consultation. Just get some clarity on the situation and then make a decision on whether or not it's the right thing for you. And if you don't have a lawyer, you should go and look for one. As you know, I am a lawyer. 212-406-8989. So please, if you need any help, give me a call. If you're enjoying the content that I provide you and the information to help you with your case, please hit the like button and subscribe. As always, folks, if you have questions, please post them up here and I will do everything I can to get to all your questions. But with that, folks, thanks so much. I wish you all the best and I hope everybody's safe. Bye-bye.